We have a terrific panel for you this afternoon, and we're going to talk to you about arbitration, mediation, private judging. I thought I would start by talking about some of the advantages and disadvantages that people perceive from a court proceeding to an arbitration proceeding, and I am going to Richard's Bible. Richard is the co-author of the Rudder Group Practice Guide on ADR, as many of you know. It is, however, a much smaller volume than my work on the Rudder Group. My volume is, my work of art is 3 volumes. Richard's is only 1. And my volume is also much prettier. Mine is pink. Now, Richard's former partner and my co-author of the Employment Litigation Practice Guide selected that color. I had nothing to do with it. But I do want to tell you that Richard was an immense help in drafting the Litigation Practice Guide. I believe Richard wrote the first draft of the arbitration section. Some of the potential advantages in arbitration: quicker results available rather than in court. Shorter, less costly proceedings than court trials because technical rules of evidence and procedure do not apply or are often relaxed, resulting savings both in litigation expenses and clients' time and effort. Greater choice in the selection of the fact finder and better qualified fact finders. Greater privacy than judicial proceedings. From a defense standpoint, no exposure to runaway juries, less risk of punitive damages. From a public policy standpoint, less burden on the courts and more community involvement in the dispute resolution. Potential disadvantages: perception of justice by halves. Arbitrators give you half of what you ask for. No discovery, no jury, no summary judgment. Some arbitrations are slower than court proceedings. Some arbitrations are more costly than court proceedings. No assurance the arbitrator will apply rules of law. More procedural issues. Opposing parties wishing to avoid arbitration can utilize various procedures to challenge the delay of the arbitration hearing and also challenge the award. Limited judicial review. Inability to join third parties. Malicious prosecution action usually unavailable. Now, I realize that some of these apply, some of these don't apply, depending on the kind of case that you might be bringing. I want to share with you a couple of my personal experiences. Actually, when I came to the program today, I ran into Cliff Pileski. Cliff asked me if I had tried a wrongful termination case, and I said yes, and he said, "Would you tell us about it?" I'll take a couple of minutes to tell you a couple of war stories. This was a wrongful termination case. I represented the plaintiff. It took me 6 years to get it to trial. I prepared it 5 times. By the way, it was here in Alameda County. By the time I got it to trial, the client had virtually run out of money, and I and my firm had to carry it. When I got the trial judge, I realized that he had a business background, so I waived jury. In that trial, my client got a judgment of 7 figures. I realize that's very small compared to Cliff's work, but it was pretty big to me at the time. But I want to tell you that there was no arbitration clause. It was an employment agreement, but there was no arbitration clause. For that plaintiff, an arbitration clause would have been the ideal remedy because this was not a rich individual. He did not have the money to spend on this case for 6 years. And if my law firm had not proceeded with it, he would have been out of court. The second case, these were actually the final 2 cases that I litigated as a lawyer in private practice. The second case was a construction arbitration, a AAA arbitration in Los Angeles. I represented the general contractor. The owner sued the general contractor for construction defects. I just decided that I would file a cross-complaint for the amount of the contract that was not paid. 3 outstanding arbitrators. You can already tell how this came out. A construction attorney with extensive experience and background in construction work, 2 engineers with extensive background in construction work. Another 7-figure arbitration award to my client, who was the defendant, nothing for the plaintiff. Now, I thought after these 2 cases, it doesn't get any better, so I better apply for the bench. So I did, and fortunately Marvin Baxter was the appointment secretary, so I went on the bench 6 months later. But these 2 cases juxtaposed illustrate the kinds of remedies that are available in arbitration that are not necessarily available in the trial courts. And that's why I went down the list of all of the pros and cons that are often perceived when you get into an arbitration situation. In all cases, they are not necessarily true. It depends on the individual case that you happen to have walk into your office. We have assembled today an outstanding panel of experts, 1 from academia, 1 from private practice, 1 from JAMS. These are true experts in the field of arbitration. I would like to introduce them to you, and then I'm going to ask them this question. How has your professional background and experience shaped your perspectives on arbitration issues facing the courts? I've already told you some of my personal background. I'm going to tell you some of the background of our outstanding panelists. And I'll start with Richard Chernick down at the end of the table. Richard is the Vice President and Managing Director of JAMS. He has conducted hundreds of large and complex arbitrations and mediations, employing various rules before major administering agencies, both domestic and international. Specific subject matters range from commercial, real property, employment, entertainment, intellectual property, technology, telecommunications, biotechnology, construction, to public law matters. He's the author of many leading texts on ADR. He's a frequent lecturer and trainer on arbitration and mediation. Richard is the former chair of the Dispute Resolution Services of the ABA, founding president of the College of Commercial Arbitrators. He served as the ABA advisor to drafting committees of the revised Uniform Arbitration Act. He is a fellow of the Charters Institute of Arbitrators. He is a former partner of Gibson, Dunn & Crutcher, also an associate at that law firm, specialized in commercial litigation, business, and international arbitration. He is a past president of the Los Angeles County Bar Association, the Legal Aid Foundation of Los Angeles, past chair of the Board of Dispute Resolution Services. He is a former law clerk of one of my former distinguished colleagues on this court, Chief Justice Don Wright. Next to Richard is Michael Rubin. Any of you who have had Michael appear in your court know that he is an outstanding appellate attorney. He is a partner in the law firm of Altshuler Berzon, where he specializes in complex civil litigation, class actions, and particularly on behalf of workers and labor unions. He is a graduate of Brandeis and Georgetown Law Center, served as a law clerk to Justice William Brenner, Chief Judge James Browning of the Ninth Circuit, and Judge Charles Renfrew of the Northern District. Mr. Rubin has argued numerous cases involving permissible scope of mandatory dispute arbitration agreements, including Gentry in my court, Armendariz in my court, the Circuit City Stores before the U.S. Supreme Court, Duffield before the Ninth Circuit. He also represented parties in arbitrations and has served as an arbitrator in individual and class arbitrations. In 2002, Mr. Rubin was named the California Lawyer of the Year by the California Lawyer magazine. 2003, he was the recipient of the Trial Lawyer of the Year award from the Trial Lawyers for Public Service for his role in the Mariana Sweatshop litigation. He's a recent inductee into the College of Labor and Employment Lawyers, has for several years been listed as one of the best lawyers in America for labor and employment law. To my immediate left is Professor Deborah Henzler. Professor Henzler teaches courses on alternative dispute resolution, complex litigation, the legal profession, and uses of policy analysis in the law and empirical research methods for social legal studies. Prior to joining the Stanford faculty, Deborah was a director of the Rand Institute for Social Justice, a faculty member of the Rand Graduate School, and a member of the faculty of USC. Professor Henzler's research focuses on dispute resolution in ordinary and complex civil litigation. She is a lead author of a book called Class Action Dilemmas, Pursuing Public Goals for Private Gain. She had written extensively on asbestos litigation, alternative dispute resolution, class actions, multi-district litigation, massive torts. In December of 2007, she hosted an international conference on the globalization of class actions at Oxford University. Professor Henzler received her PhD in political science from MIT in '73 and AB from Hunter's College in 1963. She served as a director of the American Bar Association and the American Judicial Society, and is currently a member of the Rand Institute for Civil Justice Board of Overseers. In 2002, Professor Henzler was elected a Fellow of the American Academy of Political Science and Political and Social Science, received the Robert McKay Law Professor Award from the Torts and Insurance Practice section of the ABA. These are three distinguished colleagues in the area of arbitration, mediation, and private judging. I would like them to give you their impressions on how their background and experience has shaped their perspective on the current issues facing arbitration. Deborah?
Okay. Thank you very much, Justice Chin, and thank you all. It's delightful to be able to participate in such an interesting conference with such wonderful speakers. I think as you just heard Justice Chin describe my background, it will not be surprised to know that the perspective that I bring to discussions of arbitration is the perspective of a public policy analyst. As a public policy analyst working in the area of the law, I view arbitration and other forms of alternative dispute resolution as part of the larger justice system. I believe that the questions we need to ask with regard to arbitration are the same kinds of questions that Justice Durham and her colleagues just spoke to us about when they spoke so evocatively about the need to protect our public justice system. That perspective leads me to ask questions about what are the consequences of courts encouraging, facilitating, and sometimes ordering arbitration or indeed mediation, which is not the subject of this meeting. What are the consequences not only for the parties and the profession, but also for the public at large? And I think that those questions with regard to arbitration are particularly important when we focus on mandatory pre-dispute arbitration, the situations in which at least one of the parties to a contract has not been given the opportunity to consider the costs and benefits that Justice Chin so well articulated with regard to arbitration. And then finally, given my own particular training as a policy analyst, I always want to ask, where are the data to support any policy claims that are made? Thanks.
Michael?
My background, as Justice Chin said, indicates that I've worn several hats in the arbitration arena, both as an arbitrator, as a litigant in arbitration, and as an advocate in many instances challenging mandatory arbitration. Today, I think I'll focus less on the hats than on the tie, because I pulled out of my closet, this tie belonged to beloved Professor David Feller from this institution, who was someone who a lot of us have learned a tremendous amount from, and always taught very important lessons to those who were interested in the arbitration field about how arbitration grew largely out of the work that he did on the Steelworkers Trilogy in the 60s, and how important it was for him to help devise conceptually a system of justice that worked in the labor arena, where you have parties of equal bargaining power, and you have a select group of skilled, knowledgeable, and experienced arbitrators who can resolve those disputes, with the ultimate goal being the attainment of labor peace, because the goal of labor arbitration is different than the goal of commercial arbitration or consumer or employment arbitration. And he contrasted that, and we contrast that with the system of employment arbitration we're dealing with today, which in the years since Justice Chin has been on the bench has probably evolved a great deal from what it may have been, where it is now largely a self-help remedy, where those who have the power often exercise that power in their own self-interest, where employers or large companies, with respect to their consumers, are able to create the rules. And certainly, if a quick, inexpensive, fair, and just system of alternative dispute resolution can be crafted, and all parties voluntarily agree to participate in that system, that's a lovely alternative to the judicial system with all of its backlog and all of the issues that it confronts. But what we have seen is in this field, if you compare employment and consumer arbitration to commercial or to labor arbitration, it isn't fair. It is stacked. There is some equal bargaining power now starting to come into play as a result of class action arbitration, where the parties to the arbitration have more equal economic strength. But otherwise, it is a skewed system. It is a private justice system, with due respect to Mr. Chernick. And in many instances, particularly for the sort of workers that I tend to represent, low-wage workers, immigrant workers, workers who are not familiar with the legal system, who couldn't afford to pay their attorney for 6 years of litigation before they ran out of money, it is often not a fair and not a just system.
That isn't the first time that Michael has told me that I'm way behind the times. Richard?
When I was a very young lawyer at Gibson, Dunn & Crutcher, I inherited an arbitration case from a lawyer who was departing. And were that case in court, I would never have been permitted to handle it on my own, because young lawyers weren't permitted to do that in large firms. But because it was an arbitration, no one took it very seriously, and they sent me out to try my first case. It actually happened to be a construction arbitration with 3 very fine, experienced arbitrators. And I found myself very comfortable in that process because it had very few rules and lots of flexibility, and the parties there wanted to be there and had a problem to solve and worked to figure out an efficient and effective way to solve that. As a result of being exposed to that case, much of my litigation practice over the years at Gibson Dunn consisted of arbitrations and other non-traditional forms of litigation, and along with Dan Kolke, who's in the audience, we became sort of the resident experts on weird litigation procedures at Gibson Dunn, and ended up being called upon to handle those matters, because most of the trial department really was only interested in doing jury trials. So with that experience over the years, and with growing and larger and more interesting cases, I found that the arbitration process was amazingly adaptable to solving big disputes between parties who had substantial equal bargaining power, who were interested in finding a customized resolution to their dispute, which could be very simple, could be very complex procedurally, depending upon the needs. And that's very much emblematic of how the arbitration practice has grown in the commercial sector for the last 25 or 30 years, supported by Supreme Court jurisprudence, both this court and the United States Supreme Court, in finding that arbitration is a favored form of dispute resolution, and that when parties enter into agreements, they can expect those agreements to be enforced, and when they choose procedures that are adapted for their particular needs, they can expect those procedures to be enforced and have the opportunity to enjoy that kind of a process. All of that training has helped me at JAMS to develop a national arbitration practice, which consists mostly of very large complex cases where all of the parties are interested in being there and in finding, selecting the neutral or neutrals that they want, in devising processes that they want, which might be quite elaborate, they might be quite simple, but they are helpful to what they think are the unique needs of that case. And I think that that part of the arbitration world is a counterpart to what Michael talks about. And obviously, JAMS doesn't find itself involved in very many of the consumer or smaller employment cases because people aren't interested in bringing those cases to us. And so I don't have very much to say about that end of the practice, but I'm sure I'm going to be a counterpoint to Michael throughout the day here.
Michael, you touched on this, but can you elaborate on the principal differences as you see them between the large commercial arbitrations that Richard is talking about and the labor and employment and consumer arbitrations? How do they differ, and what effect do they have on the standards that the court should use in enforcing the different kinds of arbitrations?
Richard is absolutely right that the flexibility of arbitration is a wonderful thing, and the ability to resolve disputes quickly and fairly is a wonderful thing. And as long as the parties have equal access to the system and an equal say in setting those rules, then I think that we're all strong advocates of the arbitration process. Whether arbitration is just one more economic weapon, as it is in the labor context, whether it is a sophisticated mechanism for experienced, thoughtful, knowledgeable, well-represented companies to negotiate the most efficient and flexible means of resolving their dispute, it can be a very beneficial system. Where you have, as I said, a situation where the rules are imposed on one side, then the courts need to step in. The rules that have developed around the system of arbitration presume voluntariness. In Armendariz, your court said that voluntariness is a bedrock justification, and all the decisions of all the courts have kept talking about arbitration being a matter of consent, not coercion. As long as that's true, as long as the parties can develop their own systems, then it's a terrific system. But as Professor Henzler may address later, recent studies have shown that large companies, when you look to see how they structure their dispute resolution mechanisms horizontally with competitors, with vendors, with those that they're doing business with, versus vertically, their consumers or their employees, the authors of these most recent studies have found that most of their relationships do not require resolution of disputes through arbitration when it's company on company, merchant on merchant. Even though that was the impetus behind the Federal Arbitration Act in 1925, where they have arbitration schemes is most commonly where they can impose their rules for their benefit. So how that affects the court standards is simply the hands-off standards of judicial review that have been so important in order to ensure that arbitration is a quick, easily resolved, final process. We want an answer. We want certainty. These are very important principles in the business world. When you're talking about unwaivable labor code rights or consumer rights, there is a greater element of fairness, precedent development as well, and there the courts need to step in and evaluate the process with far greater scrutiny than in the merchant-to-merchant context.
Much has been said about the courts, the public policy favoring arbitration. But Deborah, what exactly is that policy? And for example, is clearing the court's docket a legitimate public policy?
Well, one of the things that I find most interesting reading the case law particularly the US Supreme Court's case law as it evolved during the 80s and 90s, is there is the repetition from opinion to opinion that we have public policy favoring arbitration. But just why we have public policy favoring arbitration is scarcely articulated. Now, in some of the early cases, I think there's at least an intimation that the court was influenced by arbitration in the collective bargaining sphere, even when they were deciding cases under the FAA, that at least some of those who wrote opinions had in their minds this notion of arbitration as a process that engaged equally well-positioned parties and that was intended to contribute to labor peace. And it seems a rather easy move to think that arbitration similarly would be structured so that you would have equally positioned parties and that it might contribute to something analogous to labor peace, that is, peaceful communities. And indeed, the expansion of the scope of the FAA to occupy most of the terrain that had previously been occupied by state doctrine, and then the expansion of the FAA to include statutory claims of a wide variety and circumstances of an ever-increasing variety, in my view, dating particularly to late 70s, early 80s, and on into the 90s, coincides with the rise of the ADR movement, which created a culture that, at its extreme, I see as being anti-court, and as its less extreme, certainly is a culture that celebrates voluntary dispute resolution. So what could be the public policy outcome, consequences, objectives and consequences of arbitration, and then is there any evidence to support them? Certainly those who have experienced arbitration of the type that Richard's long been engaged in think of objectives like speeding disposition, as Justice Chin described in his example of his employment case, of getting parties to a remedy faster and cheaper, and one would think as a result of increasing access to dispute resolution. And if you believe that arbitration is, as the US Supreme Court said in Mitsubishi, simply a different forum, but is not intended to change the remedies, and if you believe that was true, then one could well see why this would be an attractive policy. I've actually, in the last month or so for an earlier conference, have been combing through the recent empirical research on arbitration. And as always, when you look at empirical research, much research is incomplete. Some results are ambiguous, and so different scholars would reach different judgments. My judgment is that there's virtually no research to support either the worst claims about the effect of arbitration overall, although there are certainly individual anecdotal cases, nor the more positive claims that are made for arbitration. That is, we actually don't know whether arbitration, as it is practiced today, either in employment arbitration or in consumer arbitration, speeds or slows cases, increases costs or decreases costs, increases access or decreases access. And of course, the answers might well be, well, it depends on what the circumstances are, and I can tell you that the research doesn't even begin to deal with the issues of circumstances. So finally, trying to
Can you address some of the reasons why it has been so, because there have been many studies published in recent years, and they tend to criticize each other's methodologies, but it may be interesting to address some of the reasons why we're not able to develop an empirical literature of the efficacy of arbitration.
Okay, well, I'll try and spare you the hours-long lecture that I would give my students in my empirical research methods class.
Don't worry, I'll interrupt.
But basically, if we want to understand the consequences of arbitration by comparison to use of the court system, we need to have data on the full full history of what happens to cases in courts, right? Cases are filed in courts, some of them are dismissed, some of them are dropped, some of them are decided on summary judgment, and as we all know, a very tiny percentage of cases actually reach trial in virtually every category that we can think of civil litigation. And the research, such as it is, compares outcomes at arbitration to outcomes at trial, okay? It's like comparing apples and oranges. In addition, we should expect, and indeed one of the hoped-for gains of arbitration is that it would affect people's forum choice. And so not only is it necessary that we know what happens in the full history of cases, and of course we need enough cases so that we can make a judgment on average, this is what we find, but we'd actually like to see what difference what the mix of cases is that goes into the court system versus the cases that go into the arbitration system. So it's extremely difficult research to be done. In some instances, I believe it would be doable, but as far as I can tell, it has not been done. And the final point, of course, but this is a large point, is that arbitration, of course, is private. And because it is private, even if I could set up the research design that would be necessary to do the comparison between litigation and arbitration, in general, I can't get access, nor have other researchers been able to get access to the data that we would like that would come from the private ADR providers.
There is a concept that I'd like Michael and Richard to address, assuming that it applies in the commercial arbitration arena, Richard. There is a concept called the repeat player effect. Michael, what is it? Is it a problem? And what is the solution to the problem?
The repeat player effect is the problem that arises from, call it arbitral capture, where an arbitral system is set up so that one company, entity, industry, category of individuals is a repeat player and is the one selecting the arbitrator or the ADR provider. And the notion of capture, which the California Supreme Court has addressed many times in many cases, is that there is likely a bias, whether conscious or unconscious, to favor the entity that continues to bring you business. In the commercial sphere, repeat player is not a problem. On the horizontal level, everyone's repeating. There's no benefit. In the labor arbitration context, union, employer, repeat players, not a problem. In the more skewed situation that I'm used to dealing with, a tremendous problem. The California Supreme Court in Armendariz tried to address one problem that was being confronted, the expense of arbitration, by requiring the employers to pay the costs, which to some extent exacerbated the repeat player problem. But as the court noted, who pays the arbitrator is far less important than who continually hires the arbitrator, because arbitration is a business, and it's a very successful, very profitable business, and the risk, whether it's real or not, the perception is, with many people going into the system that's already a private system, already a system that doesn't create precedent, already a system where there's tremendous confidentiality, is that the deck may be stacked in favor of the repeat player. It was as long ago as 97 in Angala that Justice Kennard, in her concurring opinion, And I think that was the first time this court, any of the justices in this court, have pointed to the problem. How the new possibilities for unfairness arise as arbitration ventures beyond the world of merchant-to-merchant disputes, in which it was conceived, into these consumer and non-union employment situations. In addition to the take-it-or-leave-it contract of adhesion, you've got the fact that the business organization imposing the arbitration clause is a repeat player in the arbitration system, while the consumer or employee is not, and that raises the potential that arbitrators will consciously or unconsciously bias their decisions. And so courts have been struggling with how to rebalance the field in order to avoid what is, at a minimum, a perception of bias because of the economic interest in arbitrators or arbitral providers in getting the business the next time and being selected. Now, JAMS and AAA deal with this in several different ways, and Rich should probably address that.
Sure. Obviously, the big difference between courts and arbitrations is the financial interest of the provider or the arbitrator, so that there is something that may motivate the trier of fact that simply is not present in the court system. It's present in commercial cases, it's present in consumer and imposed arbitration cases, because everyone is human and everyone is suspicious about people's motives. One of the things that has happened in the commercial market, as more and more lawyers and more parties use arbitration, is that there is a significant network of information about arbitrators. And there is significant research that is done every time a strike list is sent out or parties sit down to pick an arbitrator, to figure out who is an appropriate person in terms of their skill set and who's an appropriate person in terms of what their biases or feelings might be about the issues or the parties or the lawyers in the case. And I know for a fact, it's anecdotal fact, and I think that Deborah might give me a ding on this one, but it is a fact of life that arbitrators make their reputations based on their perceived neutrality in the marketplace, and arbitrators who don't have that quality, either because they favor one side or the other, or because they like to try and split the result to make everybody happy, very quickly find that their phone stops ringing because people know that, and there's very good general communication about that. On the consumer side, there was an effort by the Judicial Council to deal with this issue by adopting very elaborate rules on disclosures that arbitrators should make in cases, neutral arbitrators. And there was a Blue Ribbon Commission that I participated in that resulted in the adoption of the standards of ethics for neutral arbitrators, which has created an additional significant layer of difficulty in getting arbitrators appointed in cases because of the intricacies of maintaining sufficient databases both for individual arbitrators and providers, which information then is provided to the parties, and frequently in quantities that make the parties unable to figure out which of that data is going to be helpful to them in coming to a conclusion about what this arbitrator's experience or predilections might be. So while it was well motivated, it didn't, I don't think, go very far in helping the repeat player issue on the consumer side. What it has done, and this is typical of the way people approach problems about consumer and imposed arbitration, is that it has also had a consequence in the commercial world, because unfortunately, for the most part, those rules didn't distinguish between commercial cases and consumer cases, and for the most part, in commercial arbitrations, the arbitrators are still obligated to adhere to this very detailed and elaborate set of rules, which has become sort of a trap for vacature. When somebody loses a big case, the first thing they do is go about and investigate what maybe they should have done before they chose that person, but looking for something that wasn't disclosed that would provide a basis for that would have provided a basis for disqualification, and which under California law provides a mandatory basis for vacature. It's unfortunate that that happens. It's unfortunate that the commercial arbitration world has been swept into that, And it's unfortunate that many people don't think about the arbitration problems as being, as having two different aspects in terms of problems that maybe can be solved on the consumer side and problems that ought to be addressed separately on the commercial side.
Putting aside for a moment the issue of whether the California disclosure requirements are too burdensome, too complex, provide too much information that creates too much complication or is a ground for vacatur later, do JAMS, AAA, other large providers nationwide, not just in California, provide information that allows new parties into the system, new litigants, new arbitrants, to evaluate the records of the arbitrators? And what do you think the ideal level of disclosure would be to enable those who aren't as familiar with the arbitrators to make the decision who to select?
Well, certainly JAMS, JAMS is in a unique position because all of our arbitrators are employed, not employed by JAMS, they're independent contractors, but they are full-time at JAMS, and therefore all of their data about all of their cases is maintained on a single database. So JAMS is capable of and does produce a comprehensive computer run which reveals all of the information that's required to be revealed under the disclosed under the standards of ethics for arbitrators, and has prepared a checklist which makes the arbitrators go through the process of thinking through each of those issues, not just prior cases, not just prior experiences with particular parties, but all of the issues that are required to be disclosed under that scheme. Other providers have the problem of only seeing their arbitrators once in a while, and therefore they have to rely on the arbitrators to maintain their own databases. And having seen disclosures by other folks, everybody has a different idea of how to collect information and how to present it. And so it's very uneven in presentation, so that it is difficult in many cases to figure out exactly what information is there that would be helpful to the parties in finding out about the proposed arbitrator. But new entrants, new parties who are only going to be there once and never again, as opposed to the company which has a program which requires them to be at JAMS or AAA regularly, are not ordinarily representing themselves. They're represented by an experienced employment lawyer or sometimes a consumer lawyer, and they are regular players in this field. There is an employment bar. There is a very high level of available representation in employment cases in arbitration. And by the way, cases that of that size are manageable in arbitration for private lawyers, where frequently they wouldn't take the same case if it were in court because of the more elaborate procedures and the more daunting kinds of cost issues that can be occasioned by court litigation with elaborate motions for summary adjudication and elaborate discovery. So that we frequently see lawyers regularly appearing in arbitrations at provider organizations like JAMS and AAA in employment cases. They are regular players. They know the people. They have access to information either through their firms or through organizations, and all organizations keep that data. And the lawyers regularly use that information effectively to get what information they need, as well as whatever information is publicly available through Google, available on websites, and available through obvious reference sources.
Richard, does the disclosure include financial disclosures?
Absolutely.
And is there a limit, a minimum limit?
I believe that the California...
Same as the 1,500?
I believe it incorporates the judicial ethics. 170.1 is incorporated into the California Arbitration Act, so that we have judicial disclosures to make as well as arbitration disclosures, statutory and by rule, so that there really is a matrix of things that we're required to do. And it's I wish I had with me the 5-page questionnaire that JAMS sends out to me every time I'm proposed on a case and asked to provide disclosures. That 5-page questionnaire has attached to it up to 20 or 30 pages of computer data for every party in the case, every lawyer in the case, every firm in the case, every lawyer who's ever been at a prior firm who is now associated with the current firm, and the information is significant, and that's the commercial side. On the consumer side, there's a whole additional dimension of disclosures from the provider about all of the contact that the provider has had with the particular party. So it could be, in many cases, we've actually stopped sending this stuff out in hard copy and now send it out by email because it's upwards of 50 to 100 pages sometimes on the consumer side if you have someone in there who's been there often.
What are the societal consequences of privatizing a large part of our judicial system? Deborah?
Well, I think they're myriad. One is the obvious potential to reduce the precedents. We have cases, conceivably cases involving important issues. We look to the courts to articulate norms, to set standards, to interpret the law. And when we ship lots of such disputes off to private for, we don't get that benefit from the court. And there is also, and this is speculative, but the interesting question as to whether by pressing some kinds of cases to go into these private for, whether the reduction in precedents, rather than being across the board, is actually losing us selective information, which one might argue would be more disturbing. Secondly, this is a view that I don't know is widely shared, but I worry that in much of the law, although not, I'm pleased to say, in recent California Supreme Court opinions, but many of the US Supreme Court opinions and opinions that proceeded in this state in earlier years, there is at least implicit and sometimes explicit the court articulating a view of its own institution that seems to denigrate the value of the institution. So again, harking back to the lunch discussion, if we tell people over and over again that courts are inefficient, that they're too expensive, that there's no room for you in the court, that your best choice is jams or disputes are us, then to think that that has no role in the decision-making processes of voters when they come to make the decision as to whom they should vote for in jurisdictions where they are voting, and perhaps even more important overall, if we build a society in which we reserve the courts for some tiny piece of the community's dispute resolutions, disputes, then presumably we also discourage people from funding the courts. So to the extent that the arguments for facilitating dispute resolution in part rest on the notion that the courts are too inefficient and anyway don't have enough judges and enough other personnel to deal with disputes, we give up on the possibility of telling people the courts are very important institutions. We need to fund these institutions. So there are both direct consequences that flow from many cases being assigned into private fora, and I think there are indirect consequences, and I think over time, as this movement has proceeded, at least for me, the indirect consequences have become more troubling.
May I add to that?
Yes.
I'm less concerned with the notion that arbitrations don't build a system of precedent, because I don't think that creates a significant problem until you get an entire category of cases into that system, so that as long as you have enough of the cases in the judicial system, the system of precedent will build. I'm more concerned with the privatization because of the black hole of information. Many times we have cases where an issue is willfulness, is whether the defendant has engaged in such conduct in the past. One of the problems of the repeat player in the arbitration context is that it hides who is a repeat offender. So often plaintiffs, plaintiffs' counsel, other litigants will not know information that would have been available had previous cases gone through the judicial system. That's a valuable piece of information to have. It's definitely a detriment of the arbitral system. The notion, as Richard talked about before, arbitrators are not required to follow the law. When I first learned this, it was in a case that I did with Cliff Pilevsky, the Duffield case, and we obtained in discovery the arbitrator's manual for the NASD arbitrators, and there was a whole section that basically said to the arbitrators, you are not required to follow the law. If you don't state the reasons for your decision, you're less likely to be subject to very deferential judicial review, so don't say why. Well, that can be a great negative. Many would say that it is. There are opportunities in arbitration for creative lawmaking. There are opportunities to, I looked around at the judge before, he's not here, but I've got a judge where I'm now making an argument. I'm wrong under the settled law. This will go up to the Ninth Circuit. You have to do what the Ninth Circuit says, but they're wrong, and eventually we're going to get this straightened out. I happen to have the same exact case in a class action arbitration before a Court of Appeal justice from Arizona, and I suspect I'm going to have a much easier time making these arguments there. So on all of the issues that we're talking about back and forth, there are pros and cons, there are benefits and detriments. And I think the one message that I'm trying to say is, as long as people have equal access to those pros and cons, it's a great system. Where it's skewed, then the informality and the lack of precedent building and the non-requirement to following the law creates problems.
And I think it's the intersection of voluntariness versus mandatory runs through all of these issues that we've just been discussing, including Richard's comments a moment ago with regard to the burdensomeness of these very detailed disclosure requirements now being laid on sophisticated parties in these large commercial arbitrations. We've moved to these increasing restrictions on arbitration in response to the challenges that have been made, I think properly so, to arbitration in the context of mandatory pre-dispute arbitration clauses. And so we're bearing this, aside from the public costs of moving certain kinds of cases out of the courts, for the costs for some classes of parties, potentially, of requiring them to move into private fora where we can't tell what's going on. What we are also seeing, I think, increasingly is costs that we're imposing on a system that we all agree was working really very well for large numbers of disputants who were choosing to use it and had been doing so for 100 years.
We have about 3 minutes. I didn't get to all of the questions. I want to give my excellent panel an opportunity to say in a minute whatever you want to say.
I'm going to cede my minute to Michael.
Deborah, go ahead. There are open issues. What has started as an alternative to litigation has, for many of us, turned into litigation after litigation after litigation, challenging these clauses, understanding the scope. We have cases now before the National Labor Relations Board. Prohibitions against class actions is a deprivation of the Section 7 right to engage in concerted protected activity. There are parallel claims available under Labor Code 923. The exculpatory clause doctrine is one that the court, in many instances, has come close to. It hasn't completely embraced, but it is a method of challenging these agreements that is starting to be picked up in cases around the country. And I think that one of the things that I would say is that this court has been a leader. It's been a leader in its pragmatic approach. It's been a leader in its doctrinal approach. These are tricky issues. They're issues that none of us have yet figured out the answers to. Everyone is struggling with. But if you look at the beacon decisions of this court, they're the ones that are being cited in Oregon and Washington, in the Midwest and the East Coast. They're in the consumer context in particular. Many state Supreme Courts have started following what this court has done, and I think that's continued to happen as this court grants review in these very difficult but very important in terms of preservation of justice types of cases.
Deborah?
I just want to second what Michael said. I think the court's recent decisions in this area, which I date back to Engala, which seems to me to have presented the court with the realities of what can happen in arbitration, seems to have led to a sequence of decisions which I think are importantly contextualized and sensitive to practice, and have moved away from repetition of the mantra that we support arbitration because it's good public policy, without going further. So I'm pleased and I look forward to seeing more such decisions.
I've already made my one point.
Thank you.